All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Thank you very much. Court officer, if you can call the matter, please.
Good morning. Situation in the Republic of Kenya. In the case of the prosecutor versus William Samoei Ruto and Joshua Arap Sang, case number ICC 0109-0111, and for the record, we are in open session.
Thank you very much. Appearances, please.
Mr. President, Your Honours, I appear for the prosecution, Anton Steinberg, and with me Cynthia Tai, Ade Omafade, Lucio Garcia, Lara Renton, and Grace Go.
Thank you. Defense.
Good morning, Mr. President, Your Honours. William Ruto is represented by David Hooper of Queen's Counsel, Mr. Esafal, Shamala Alagendra, Venkateshwari Alagendra, Lee Laurie, and Ms. Jaya Anil Kumar. Your Honours, my name is Kareem Khan.
Sorry, Your Honours. Mr. Sang is represented by Judy Miongi, Case Manager, Logan Hambrick, Legal Assistant, Caroline Buisman, Associate Counsel, and my name is Katwa Kigan Counsel, and I'm assisted by Joel Bosek and Philemon Koech. Thank you.
Thank you. Victims' Counsel.
May it please the President and Your Honours, I am Wilfred Nderitu, legal representative for victims. I am assisted by Mr. Ochlon Naratsetseg from the OPCV and also by Ms. Caroline Hatzig, my case manager. Thank you.
Thank you very much, Mr. Nderitu, and welcome to the courtroom. This is your first appearance.
Yes, it is, Your Honour.
Thank you. The status conference today is the last scheduled in the series of status conferences we've been having, in this case, ahead of the commencement of the trial. In today's status conference, we will be dealing with the matters that I will outline now. We will take up the matter of the prosecution's application for variation of time limit for disclosure of the identities of two new witnesses following the decision of the Chamber, dated the 3rd of September 2013. That will be the first item we will deal with. The second item would be the matter of the application from the Ruto defense for leave to appeal the decision of the 3rd of September 2013, which granted the prosecution the leave to add the two new witnesses indicated earlier. The third item would be the matter of the use of visual aids in opening statements. We will also deal as a fourth item the sitting schedule for trial. Number 5 would be any matter relating to the commencement of trial. Number 6 would be, we will touch on the matter of Regulation 55(2), pending application by the prosecution. The seventh item would be the defense's application for reconsideration of witness preparation decision. And finally, we will take on any other matter. That is the order in which we intend to proceed today. So that takes us immediately to item number 1, the prosecution's application for variation of time limit for disclosure of the identities of 2 new witnesses following decision of the 3rd of September 2013, filed by the prosecution on the 6th of September 2013, that is last Friday, in document number 914, confidential. By way of introduction, I should say that on the 3rd of September, as indicated earlier, the Chamber granted prosecution leave to add 2 new witnesses to their witness list, and that grant was made pursuant to the prosecution's application for that leave. In that decision, the Chamber required the prosecutor or the prosecution to disclose the identities of the 2 new witnesses to the defense by the deadline of 12 noon on Monday, the 9th of September 2013, that is today. The very next day, on the 4th of September 2013, the defense filed an application for leave to appeal that decision of the 3rd of September. On the afternoon of last Friday, that's the 6th of September 2013, the Chamber was seized of a confidential prosecution request for variation of time to disclose the identities of the 2 new witnesses, whom the Chamber had granted the prosecution leave to add to their witness list. By their application, the prosecution now seeks to delay disclosure to the defense of the identities of those 2 new witnesses, and further to delay the notification to the defense of the ex parte filings in which the prosecution requested the addition of these 2 witnesses to their list. We will be taking limited submissions on this matter, and it will be a 2-minute time, so I'm announcing it ahead of time now, a 2-minute time limit for submissions. Now, the basis of the prosecution's request is indicated as the need to protect the identities of the 2 new witnesses given the eventual possibility that the trial chamber may grant the pending defense request for leave to appeal the decision. And upon the further eventuality, eventual possibility, I may say, that the appeals chamber may reverse that decision of the 3rd of September 2013 if leave to appeal is granted. Question is this, and this is the question on which we seek limited submissions. Assuming, prosecutor, the materialization of those 2 eventual possibilities, and that the 2 witnesses do not end up, indeed, testifying after disclosure of their identities as ordered. What greater prejudice will result as regards those 2 witnesses in comparison to another witness whose identity, a protected witness, I might say, whose identity would have been disclosed to the defense, but that witness proceeds to complete his or her testimony in the normal course of events. Two minutes.
Thank you, Mr. President, Your Honours. The short answer is that there would be no greater prejudice to that witness than to any witness who testifies in these proceedings and whose identity is disclosed to the defense. The difference being that the necessity of the disclosure of witnesses who testify is demanded by the defense's right to disclosure and right to prepare. The prosecution's submission is that the disclosure of the identity of persons who turn out not to be witnesses is unnecessary and places those witnesses at the same risk as other witnesses for no reason, simply because if the appeals chamber upholds the appeal, and obviously if Your Honours grant leave to appeal as the preliminary step, then the evidence contained in those statements is not, in the prosecution submission, evidence to which the defense would be entitled. And the disclosure of their identities and the assumption, consequential assumption of protective duties towards those witnesses by the court would be essentially in vain. I think I still have about 30 seconds left, and I would just like to point out, Your Honours, that one matter the prosecution omitted to deal with in its filing was the issue of the notification of the ex parte version of the filings to the defense. On reviewing these filings, it appears that the redactions contained in the redacted version were not simply based on the need to protect the identity of these two witnesses, but there were further redactions that were, for instance, to information relating to witness 613's location, information which may compromise the identity of the withdrawn witness 534, and certain references to the contents of other ex parte decisions of this chamber that even once the identity of these two witnesses is disclosed, would still require ongoing redaction. So for those reasons, Your Honours, the prosecution requests a variation of the decision to the effect that rather than disclosing the entire ex parte filings, the prosecution should be permitted to file lesser redacted versions, redacting only those portions to which I have referred that do not relate to the protection of the identity of these two witnesses. And I think my 2 minutes is now up.
He was up a few seconds ago.
Thank you, Your Honours.
The question then is that you are varying your application. You made a standing application to vary the existing one. Is that it?
Indeed, I would request orally this morning for the court to vary its decision to the extent to allow us to file a lesser redacted version of our filings, the fourth and fifth request, rather than to simply notify the ex parte filings to the defense and to the parties.
Thank you. I turn the microphone to the defense counsel.
I'm grateful, Mr. President, Your Honours.
2 minutes, Mr. Khan.
Your Honour, we say that the issue of the leave to appeal should have no bearing on the order of the trial chamber. What the prosecution patently failed to understand in our regrettable submission are the contours and responsibilities that rest upon that office pursuant to other provisions of the statute, including Rule 77. On any analysis, on any view, whether or not a witness is going to be called as an incriminatory witness, evidence that the prosecution have that may be material to the preparation of the defence must be disclosed. Your Honour, these provisions are not a licence for the prosecution to withhold evidence and only disclose it if it supports their case and is incriminatory, and yet to keep it under wraps if it is exculpatory or otherwise will help inform defence preparations or the defence understanding of the case that the defence have to meet. Your Honour, the argument put forward by the prosecution of unnecessary relocation is a red herring. Firstly, there's no reason in law or practice or principle, we say, for the prosecution to say individuals should be relocated only in the event that they become prosecution witnesses. They have an independent obligation under Article 54 to look at exculpatory evidence as well. So relocation can't be confined only to material that's incriminatory and not evidence that is otherwise material to the preparation of the defence. Your Honour, the other aspect, the prosecution can't have it both ways. In response to previous filings, we had complained about allegations that were being bandied about with abandon. My learned friend very properly and courteously said, reassured all parties on the bench that the prosecution have no concerns regarding the conduct of this defence team. We're not asking for disclosure to the public at large. We're asking disclosure to a defence team that the prosecution themselves say they have confidence and not engaged in any foul play. In those circumstances, Your Honours, we say that the application should be rejected.
Thank you very much, Mr. Ken. Mr. Gigenkap.
On our part, Your Honours, we rely on the provisions of Rule 76 and maintain that we will suffer prejudice if the names of these witnesses are not disclosed prior to the hearing date. And so whatever nature and approach is given to this matter, we would want the disclosure to be given ahead of the date of trial so that we are able to investigate and apply the results of those investigations in the course of the trial right from the first witness. Thank you, Your Honour.
Thank you very much. Mr. Director, do you have submissions in this regard?
Yes, thank you, Mr. President, Your Honours. Just very briefly, I do share the submissions from my colleague, Mr. Steinberg, with regard to there not being any greater prejudice to such witnesses as to any witness who testifies. And I would only want to limit myself to say that at this point in time, it is not known whether the two intended witnesses will be dual status witnesses or not. And therefore, I share only to the extent that they may be of relevance to my mandate. Thank you.
Thank you very much. And the chamber will rise for 5 minutes and we will reconvene.
All rise, veuillez vous lever. All rise, veuillez vous lever. Please be seated. Veuillez vous asseoir.
The chamber will now render its ruling on that application. On the afternoon of last Friday, the 6th of September 2013, the chamber was seized of a confidential prosecution request for variation of time to disclose identities of the two new witnesses whom the chamber had granted the prosecution leave to add to their witness list. That leave was granted in the chamber's decision the 3rd of September 2013. In that decision, the chamber required the prosecution to disclose the identities of the two new witnesses by 12 noon today. By their application filed last Friday, the prosecution now seeks to delay disclosure to the defense of the identities of those two new witnesses and to delay the notification to the defense of the expletive filings in which the prosecution requested the addition of these witnesses to the witness list. The defense need not respond further to this application beside what was submitted upon earlier in the morning. The prosecution's reasons for their request for delayed disclosure are premised on the eventual possibility that the chamber may grant the pending defense application for leave to appeal the chamber's decision of the 3rd of September 2013, and further, the eventual possibility that the appeals chamber may overturn that decision if the trial chamber grants leave to appeal. For one thing, the speculative nature of these eventual possibilities are, in the chamber's view, an unsatisfactory basis to grant the prosecution application in light of a trial that is scheduled to commence tomorrow. Moreover, the equities of the matter place the heavier weight of prejudice on the defense if the prosecution's application is granted than would be the case if the application is rejected. In particular, the chamber's decision to grant the prosecution the leave in the first place to add the two new witnesses was based in an important way on the consideration that disclosure of their identities to the defense by the 9th of September 2013, that is today, would give the defense a relatively fair opportunity in the circumstances to carry out additional investigations prior to the testimony of these witnesses. If the chamber at this stage were to allow the prosecution to withhold the identities of the two witnesses pending the possible or the possibility of any decision of the appeals chamber, it would mean that the prosecution would only disclose the identities of the witnesses in some months' time. This would negate an important consideration in granting the prosecution's leave, the prosecution leave to add the two new witnesses to their list. What is more, the prosecution has admitted that no greater prejudice would be occasioned the prosecution or the witnesses if the disclosure is made by 12 noon today. That would be the case were the appeals chamber eventually to overturn the chamber's decision of the 3rd of September 2013. That is to say, increased prejudice is not engaged as regards a witness whose identity is disclosed to the defense and the witness does not testify as expected due to the operation of an appeals chamber's decision, in comparison to a witness whose identity is disclosed to the defense and the witness does testify in the case as expected. For the foregoing reasons, the chamber rejects the prosecution's application. As regards the varied application made standing up this morning, the chamber notes that in its decision of the 3rd of September 2013, the Chamber had invited the prosecution to make any application for further reductions that it saw fit to make. The Chamber takes it that what was done, standing up, was a fulfillment of that invitation to the prosecution. And the matter would then be governed by the standing protocol on reductions. As the request is rejected, the prosecution is to disclose the identities of the two witnesses and notify the prosecution's related ex parte filings to the defense by noon today, as ordered by the Chamber in the decision of the 3rd of September 2013. That concludes the Chamber's ruling on the matter.
As the Chamber pleases, Mr. President, there is the logistical issue, of course, that the persons who will be involved in that disclosure are sitting here in court. We could do the disclosure during the lunch break, or if it's all the same to the defense, we could do the disclosure immediately after the finalization of the status conference. But perhaps I could ask my learned friends to indicate which would be more convenient to them.
Your Honour, if we finish by 12 o'clock, if we're not finished, then when we come out of court, if it's ready, that'll be fine.
So it will be then.
As the court pleases.
I understand that there is a matter, something else outside the courtroom that the parties would need to attend to at a time.
Indeed, Your Honour, there is a press conference that we were asked to attend. I think all parties, the prosecution, the registry, and once the defence were also invited to attend. I understand it's at, I think it's at 2 p.m. because it's changed a few times. I stand to be corrected. I will try to verify it.
At 2 p.m.?
I understand that's correct. No, Your Honour, bear with me one moment. I think we're wrong. Your Honour, it's at 12 noon, the press conference. Great.
That's what we thought.
Okay. Yes, thank you.
Well, we must make best use of the time we have until then and move on with the other matter on the agenda. The next item to take up now would be the matter of the defense application for leave to appeal the decision of the 3rd of September 2013, to which reference has been made so far in our proceedings this morning. The Chamber will now take an all parties submissions on this matter. I note that the defense's application contained 3 prayers, the main one, of course, being the leave to appeal the decision. The second prayer is a request for adjournment for 4 weeks, either following the opening statement or opening statements of the parties, in this case tomorrow, or after the first 2 witnesses have testified. And the third prayer is a request to shorten the deadline for response. The third prayer has been overtaken by events, because by Chamber's decision of the 5th of September, the parties were directed to make their submissions orally in court today. So I will now take submissions from the parties. The defense will I will give the defense, the Ruto defense, that is, 5 minutes to recap or update their motion, since we have it already in writing, and there's no need for you to repeat everything you've said. We have the submissions in writing.
I'm grateful, Mr. President, Your Honours. I think we can rest on our written submissions and, with your leave, respond to anything raised by the other party, by the prosecution or the victim's representative today.
And that's a fair way to proceed. Now I turn to the prosecution and the other participants in the case. Mr. Prosecutor, approximately how much time do you need to make your submissions?
Your Honours, I would expect that 10 to 15 minutes would suffice.
Mr. Keegan-Carter, and you?
Your Honours, about 7 to 10 minutes.
Okay. Mr. Andiretu, can you give me an idea of how much time you'll need to address this matter?
At most 4 to 5 minutes.
All the time indications are within what we thought would be the case. So, Mr. Prosecutor, you have the floor now.
Thank you, Mr. President. The prosecution opposes the defence application for leave to appeal on 2 main grounds. Firstly, the 2 issues identified by the defence in the prosecution submission do not arise out of the impugned decision. And secondly, the 2 issues do not meet the criteria for leave to appeal under Article 82(1)(d). Turning to the first issue is whether the trial chamber erred in authorizing the addition of these 2 witnesses to the prosecution's list of witnesses by failing to assess whether any replacement for the evidence of P534 is required, and secondly, whether the evidence of P604 and P613 actually replace the evidence of witness 534. In the prosecution submission, this issue is based on the flawed assumption that the trial chamber failed to assess whether any replacement of the evidence was necessary and whether the evidence tendered now in fact replaces it. The assumption is flawed for the following reasons. Simply because the chamber did not explicitly state that the evidence of these witnesses serves to replace 534 does not mean that they failed to consider this. Indeed, in the prosecution submission, it is implicit in the chamber's decision that they did so. For instance, in paragraph 19 of the impugned decision, the chamber refers to the similarity in the subject matter of the potential testimony of witness 534 and witnesses 604 and 613. The chamber also took note of the prosecution's submissions that 604 will help to replace the evidence proffered by 534, and that the prosecution is only replacing one source of information with another, and similar submissions made relating to witness 613. Moreover, the chamber specifically took note of the arguments of the Ruto defense to the contrary. It is implicit in the chamber's subsequent analysis of the decision, Your Honours, that it accepted the prosecution submission and rejected that of the defense. It is significant, Your Honours, that the chamber has the unredacted statements of both the new witnesses and of the replaced witness before them, and a mere reading of these statements in the submission of the prosecution will amply demonstrate that their subject matters overlap considerably and that the 2 new witnesses adequately replace the old witness. As for the necessity to replace 534, the defense once again presumes that the chamber that the chamber's failure to explicitly deal with this meant that they did not consider it. Once again, this assumption is misplaced, Your Honours, and the chamber has already had previous occasion, the prosecution points out, to consider the importance of the evidence of witness 534, and the reason why this is not dealt with explicitly is to be found in paragraph 28 of the impugned decision, wherein the Chamber refers to the fact that it relied on certain ex parte submissions of the prosecution. As a result, the prosecution submits that the first issue is based entirely on a misrepresentation and misinterpretation of the decision, and for this reason alone, the first issue should be rejected. The second issue, Your Honours, also does not arise out of the decision. It is also based on the assumption that the Chamber did not consider whether the defence has a right to undertake investigations into the credibility of witnesses prior to the commencement of trial. However, in the prosecution submission, the Chamber explicitly considered this right. It refers in paragraph 17 to the right of the accused to have adequate time and facilities for the preparation of its defence, and addresses in paragraph 19 the necessity of avoiding prejudice to the defence. Also at paragraph 19, the Chamber refers, or finds in fact, that an investigation into the credibility of the persons themselves, as opposed to the investigation of the evidence that they would present, does not necessarily need to take place prior to the commencement of the trial. This is the very issue which the defence takes issue with. In the prosecution submission, therefore, what the defence attempts to present as an issue amounts to nothing more than a disagreement with the conclusions of the Chamber in this regard. In essence, what the defence are saying is that the Chamber's decision was wrong. The case law of this court, however, establishes that a mere disagreement is not sufficient to render an issue appealable. And for this reason, too, the prosecution submits this issue should be rejected. Turning then to the requirements for leave to appeal, the first submission of the prosecution is that the issues identified do not significantly impact on the fairness of proceedings. And the prosecution points out that the Chamber was alive to the potential prejudice which its decision may cause to the defence, and specifically put in place measures to mitigate that prejudice. In particular, it directed the prosecution to call witnesses 604 and 613 towards the end of its case. As we know from the decision on the hours allocated to the prosecution, it is estimated that that case may take up to 7 months. We know from past experience that during that occasion there will no doubt be several adjournments for recesses and for other reasons, and we submit that this or these provisions that the Chamber has taken adequately provide for any prejudice which may be suffered by the defence. Secondly, the Chamber has ordered the defence to disclose the identity of the witnesses, an order which it has repeated this morning and enforced this morning. Therefore, the prosecution submits that the issues do not impact on the fairness of the proceedings, and any prejudice which might arise, which has not already been adequately dealt with by the measures put in place by the Chamber, may be addressed in the prosecution submission on a case-by-case basis as the trial proceeds.
Your Honour, can I just correct the transcript? My learned friend has stated that it's for the defence to disclose the names of the prosecution witnesses. This is one occasion where we haven't alerted the prosecution to erroneous disclosure. We've had occasion in the past. We don't know the names of these witnesses, and of course it's just a misstatement by my learned friend, inadvertent though it is. Perhaps the transcript can be corrected accordingly.
Thank you, I'm grateful. I believe I used the word defence instead of prosecution. The prosecution will disclose the identity of the witnesses today, as ordered. The defence also speculates as to the possibility of further witnesses being added. That, of course, is a matter which will be addressed if and when such applications are made, but it does not affect the fairness of this decision, or the way in which this decision affects the fairness of the proceedings. Secondly, the prosecution submits that the issues do not significantly impact on the expeditious conduct of proceedings. While we do admit that replacing witnesses, especially at a late case, may result in some delays, we dispute that it will significantly affect the expeditious conduct of proceedings, with the emphasis being on significant, bearing in mind the steps and the safeguards which the Chamber has already put in place to lessen any prejudice to the defense. I think that's all I need to say about that. Finally, the issues do not significantly affect the outcome of the trial. If, during the course of the proceedings, it becomes clear that for one or other reason which the Chamber was not aware of or hadn't taken into account, these witnesses should not have been included in the prosecution's list of witnesses. It is always up to the Chamber, up until the last minute, to revisit this ruling and prevent the prosecution from calling these witnesses. Or even after they have testified, the Chamber is at liberty, if good cause is shown, to simply disregard the evidence of these witnesses. So the mere inclusion of these witnesses in the prosecution submission does not significantly affect the outcome of the trial. And finally, the prosecution submits that the immediate resolution of both issues will not materially advance the proceedings. For those reasons, Your Honours, the prosecution submits that the application for leave to appeal should be dismissed. Your Honours, the second request of the defence, that the matter be adjourned for 2 weeks, is a matter which perhaps might be better addressed under one of the later issues which the Chamber has flagged for discussion, such as the commencement of the trial. I can proceed to address it now, or it may be more convenient to deal with various matters which might affect the impact of the trial in one go, as it were. I'm in your Honour's hands.
We prefer that you proceed now to address that issue.
As
Mindful of the time.
Yes. The defence seeks a 1-month adjournment following the opening of the trial proceedings, alternatively following the first 2 prosecution witnesses. Firstly, the prosecution notes the strange caveat in this request that the adjournment should only take place after opening statements. The defence does not explain why it specifically asks that the adjournment take place at this time. In the prosecution submission, it seems that the intention, however, is plain. It's to ensure that the trial has started in order to limit the room for movement of the prosecution to take any further remedial action to replace witnesses that might withdraw or to take other steps, whilst preserving for itself the opportunity to continue its own investigations. The prosecution submits, Your Honours, that if the court is minded to grant the adjournment of the requested by the Ruto defence, that adjournment should take place before and not after the opening statements. As to the merits of the adjournment, the prosecution submits that the Chamber has already considered and rejected this very same request. In fact, in the defence's response to the 4th and 5th, or it might have been one or the other, I don't recall as I stand here, in one of or both of the prosecution's requests to add witnesses, it indicated that it would require a further 3 months or a 3-month adjournment in order to prepare its case. And in the decision 899, the Chamber specifically considered the prejudice occasioned by its decision and provided relief which it considered sufficiently counterbalanced any prejudice and obviated the need for any adjournment. So what the defense, I beg your pardon, is now essentially doing is asking the Chamber to reconsider its earlier decision, the only difference being that the period of the adjournment has shrunk from 3 months now to 1 month. The prosecution submits, however, that the defense offers no new reasons for this adjournment that have not already been considered by the Chamber, and certainly does not put forward any reasons justifying reconsideration, bearing in mind the test for reconsideration, that it must establish the earlier decision to be manifestly incorrect or unsound. So for those reasons, I submit that the defense's request for an immediate adjournment, whether before or after the opening proceedings, should be rejected. However, for reasons that the prosecution will request to go into in more details in private session, since they deal with witness-related issues, the prosecution does not oppose the alternative relief requested, namely the adjournment after the second, or after the evidence of the first two witnesses has been presented, with certain caveats which the prosecution would request to be able to return to at a later stage. I have submissions relating to witness-related problems which the prosecution has experienced, which I would prefer to deal with in private session and not in open session. And perhaps these matters, again, I'm in Your Honour's hands. I can go into them now, or it may be more appropriate to do that at a later stage.
For now, what you are saying is that your own preference coincides with the defense's alternative request.
Indeed. Even though we say that the basis on which their request is premised is incorrect in law, the prosecution has experienced certain difficulties in securing the attendance of certain witnesses, which will impact on the conduct of the proceedings. And for that reason, we are happy to adjourn after the second witness, with certain caveats.
Fair enough. Is that it for you? In terms of
If Your Honour will give me permission to return to these issues in due course, then that is it as far as my response to this filing. Thank you, Your Honours.
We can return to those details in due course. If that now concludes your submissions, then
It does, Your Honour.
this will be a logical place to adjourn in light of your earlier announced obligations. So we will reconvene at 2.
All rise, veuillez vous lever.